Hi everyone, thank you so much for coming, and there are lots of seats in the front if people want to make their way down. I'm Kathleen Blanchard. I'm one of the vice presidents of the Federalist Society. I'm a 2L here at Duke, and I would like to welcome our speakers today. Mr. Alden Abbott is the Rumpel Senior Legal Fellow and Deputy Director of the Meese Center for Legal and Judicial Studies at the Heritage Foundation. He previously served as Director of Patent and Antitrust Strategy for BlackBerry and in several senior governmental positions. He's also an adjunct professor at George Mason Law School. And our own Professor James Boyle teaches IP, torts, and several other courses here at Duke. Welcome you both. Thank you for coming.
Thank you. Oh, thank you very much, Kathleen. I owe a great debt to you and to the Federalist Society for organizing what I hope will be an interesting and stimulating debate about intellectual property and in particular patents and copyrights. And I think, as probably most of you know, intellectual property is increasingly important in the American economy and certainly has attracted an increasing amount of attention in the popular press and among scholars. And there is a strain of thought which has influenced public policy over the last decade that suggests that patent rights and copyrights and intellectual property in general somehow is illegitimate or not fully legitimate, has monopoly characteristics, is a product of special interest pleading, and can and should be weakened. And that it's also been argued that it really doesn't have much of a strong basis in the American constitutional system. I would argue to the contrary, that the framers of the Constitution and the early republic thought intellectual property rights, in particular patents and copyrights, were very important, or natural rights that deserve strong protection. And I will also argue, contra to a lot of the, I think, popular press and some scholarship, that patents and copyrights do strengthen the overall American economy, promote innovation and economic growth. Now, let me start with the IP clause of the Constitution, Article 1, Section 8, Clause 8, which says, quote, to promote the progress of science and useful arts. It creates rights for Congress to pass Congress to copyrights and patents, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. Admittedly, there's not too much history, constitutional history, underlying that clause, but I think if you carefully look at some of the writings of the framers and their grounding, you'll get a better understanding. And I think you want to go back to John Locke's second treatise. Probably most of you are aware of John Locke's second treatise of government. His political philosophy on property certainly influenced the framers a great deal. Blackstone, of course, is a leading publicist or legal commentator who influenced the framers. Now, Blackstone's second Chapter 5 of property of the second treatise of government presents a broad view referring to property as involving the exclusive rights individuals hold in their own selves and their own labor. He saw government as existing to protect the property person's claim by individual right of acquisition through their labors, which are the source of the value that is created. He did not specifically reference IP, but his own term, by its own terms, his conception of property is not limited to tangible property. It certainly could cover intangible property. Now, Madison's essay on property in 1792, as you know, Madison, the father of the Constitution, has implicit in it sort of a Lockean natural rights view of property. He says property, quote, in its larger and juster meaning embraces everything to which a man may attach a value and have a right, close quote, and quote, which leaves to everyone else like the like advantage, close quote. Now, IP as well as physical property possesses its grounding in natural right. concept of rights in an author's writings and an inventor's discoveries are implicitly encompassed within this broad understanding. Admittedly, however, the essay does little to explore the implications of the distinctions that exist among various types of property, including differences between tangible and intangible property. And for that, I will quickly read a long excerpt from actually a couple of authors whom I know quite well. Recently wrote a book on property, intellectual property rights, and the Framers' Understanding, in which, and rather than paraphrase, let me just go directly to some of what they said. Madison and the Founding Fathers held a two-track understanding of property. They also understood property in its particular application. This narrower definition separated personal rights, including public communications of opinions, liberty of conscience, and so forth, and property rights in actual possessions, such as a man's land or merchandise or money. Now, this particular application, unlike the more traditional understanding of property, was likewise rooted in natural right, but it also depended upon civil society. That is, laws established by governance expanded the scope of protected property and reflected social and technological progress. Now, intellectual property and physical property both share this necessary connection to the laws of society, and both copyrights and patents fit within the meaning of property in this narrower sense of the term. Stated somewhat differently, the sort of Lockean understanding held by Madison and the Framers, I believe, reflects the notion that a person has natural rights to the fruits of his or her own labor, rights to make use of one's faculties as a means to acquiring property as a personal right, and the right to the actual productions of one's labors as a property right, in a narrow understanding of the term. Now, this, of course, doesn't necessarily mean that in nature that there are common law supports property and copyright law, but there was an understanding in the 18th century that you couldn't rely on common law. Indeed, Blackstone, in his commentaries, wrote that the purpose of civil law is to fulfill natural rights of property by expanding property, creating new forms of property as society progresses, and ensuring mutual enjoyment of property rights by all persons. And this certainly applies to the copyright and patent laws, which, by the way, were first enacted in 1790 by the first Congress. Now, civil laws apply in unique ways to different types of property. Laws regarding mineral rights, water, real property are different than those that apply to intellectual property, but they are all positive law, civil law. So again, the idea that somehow intellectual property is not true property, which is held by, you hear by many commentators today, just doesn't hold, at least in the views, I think, of the Framers. Now, Madison also wrote, the utility of this power to protect IP, he wrote in the Federalist 43, will scarcely be questioned. Copyright of authors has been solidly adjudged in Great Britain to be a right of common law. He was wrong about that, but it's not really central. The right to useful invention seems, with equal reason, belong to inventors. Public good fully coincides in both cases with the claims of individuals. So that what the key here, I think, is that his statement that these rights belong to authors and are claims of individuals. The reference about the good of society and so forth, that you find a public good, really is a gloss on that to provide further explanation of the clause, but it is not a utilitarian statement saying this is a purely utilitarian limited right, just as I would argue the preamble of the Second Amendment about the well-ordered militia is not a utilitarian statement that limits the right to bear arms. So Federalist 43 certainly had an influence. George Washington called for the passage of intellectual property laws in his first State of the Union address. Madison strongly supported them in Congress. A number of, they passed, and indeed over the next few decades, up to sort of the mid-19th century, Congress steadily strengthened intellectual property laws. Now, there is one peculiarity I'll acknowledge. In the 19th century, most of the 19th century, copyright law did not protect the writings of foreigners, and which Charles Dickens was very concerned about, and some other authors. But nevertheless, as a general matter, that might be viewed as protectionist, whatever, but as a general matter, statutory copyright and patent law continued to strengthen. My paper discusses that at greater length, and indeed, the early publicists, Story and Chancellor Kent, wrote about the importance of intellectual property. Story writes, "It is a poor reward to secure to authors and inventors for a limited period only an exclusive title to that which is, in the noblest sense, their own property." He says, goes on at greater length too. In his commentaries on American law, Chancellor Kent phrases, quote, "the justice and policy of securing to ingenious and learned men the profit of their discoveries and intellectual labor." Again, the justice. So now the Supreme Court and the early federal courts have some very strong statements about the importance of property. Or some 19th century presidents who decried monopolies, such as Jackson, Van Buren, and Polk, nevertheless signed legislation expanding IP rights. Abraham Lincoln spoke at length in an essay about the importance of IP rights, and in the Reconstruction Congress after the Civil War continued to strengthen IP rights with the Copyright and Patent Act of 1870. So this is not to say they're counter-arguments, and I think if you look at the historical record as a whole, from the founding up to the mid-19th century, there's certainly a strong basis among jurists, publicists, framers, strong understanding that property rights are fully legitimate rights justified by natural law reasoning. Now, as to the pragmatism of strong intellectual property rights, let me turn to that now. You could nevertheless argue, well, it may be that there was some historical understanding, but Congress was given the option to create strong or weak or non-existent intellectual property rights. So you want to look at instrumentalist pragmatic arguments for intellectual property. Now, in recent years, I would argue the American patent and copyright law systems, which have been bulwarks of American leadership in innovation and creative arts, are under unprecedented attack by certain commentators. Their 2011 legislation made it easier to attack patents in administrative proceedings, not using the federal court standard, but a more permissive standard. Indeed, the Supreme Court's going to look at that this term. But there are a number of Supreme Court decisions, quite a number, that have limited the scope of patents, that have limited the ability of patent holders to get injunctions for parties who use their property. In a related way, not only the 2011 Act, which I would argue somewhat weakened patent rights, there are a number of serious legislative proposals to create special procedures for patent law, the claim being there's too much rent-seeking by so-called patent trolls and other abusers, but there's a concern that special procedures, which will make it even more difficult to assert one's patent rights, may be passed. I don't think such legislation will pass, but it's been given serious consideration. Federal enforcement agencies have become more aggressive in trying to limit returns to patents that cover key standardized technologies, and in particular in pharmaceuticals, particularly using antitrust law. And now why is this happening? And does this jibe with sort of economic thinking? Well, I argue it doesn't. While the protection of patent rights, let me talk first about patents, oscillated somewhat. The courts in the mid-20th century and the antitrust enforcement agencies were rather concerned about limiting returns to patent holders. However, starting in the 1980s, and really, I'd say up until about a decade ago, for at least a quarter century, there was a strong bipartisan consensus that allowing full returns to property rights was important. Not only the patent statute, but 1995 Clinton administration IP antitrust guidelines refer to patent rights unequivocally as property rights. They should be viewed as property rights, similar as other property, although they have obviously different characteristics. And the U.S. and the Clinton administration got the World Trade Organization to secure the adoption of strong intellectual property protection in the world in the so-called TRIPS, or Trade-Related Intellectual Property Rights Agreement. So I'd argue this is not Republican-Democrat. This was basically, and I was in government at the time, it was a bipartisan consensus. But in the last decade, there's been a theory, sort of a meme, that patent rights are problematic, they're weak. Professors Carl Shapiro and Mark Lemley wrote a number of articles on so-called probabilistic patents, saying lots of patents are of dubious quality, shouldn't have been issued. And they came up with a variety of public policy arguments to, they say, to change the system, reform the system for granting patents, reform the patent litigation system, limit incentives, change the incentives of patent holders to use cross-licenses to settle patent disputes, which supposedly was problematic. And 4, change the antitrust assessment of agreements among rivals involving settlement agreements involving patents. Now, implicit in all this was the idea that the current patent system unnecessarily restricts competition, imposes excessive costs on society. There were a couple of reports by the Federal Trade Commission. I was at the Federal Trade Commission at one point, 2011, 2003, calling for regulatory improvements, raising patent quality, promoting litigation reforms. I mentioned the Supreme Court decisions. The number of federal antitrust actions were ramped up by the Federal Trade Commission. Then in the last few years, more discussion about that by the Justice Department. Now, I'm not suggesting that there are no defective patents or copyright for that, right? But I'm suggesting that there have been abuses in lawsuits brought by patent holders. However, I guess what I'm arguing is that while no system is perfect, there's been a great deal of innovation in the U.S. economy in the 80s and 90s during the period of strong patent protection. And before cutting back on those protections based on theory, one wants to be very careful. Now, I want to, because I'm time limited, but there's a growing literature that I think counteracts this literature that patent rights are problematic. There are a number of recent World Bank and OECD studies that finding a positive association between the strengthening of IP and patent rights and important economic indicators, as well as a positive relationship between the strengthening of patent rights and increased innovation. Again, one may disagree with aspects of it, but I discuss that literature in my paper. There's also growing law and economics literature, for those of you who like that on the why patents strengthen the economy. And Professor Daniel Spolber, a leading economist at Northwestern, has written, and I think, and as have many others, that quote that patents, the system allows for the enhancing of transaction efficiencies and competition by providing exclusion, transferability, disclosure, certification, standardization. That patents help transform a market for inventions into a market for innovative corporate control by spurring innovation investment in complementary assets, and patents promote the financing of innovation and new inventions. And really the key to lots of this law and economics literature is not that individual patents may not be, quote, bad or weak, and not that many individual patents don't necessarily bring, as individual patents, great returns, but that the system as a whole is sort of a proxy in a market for corporate control to allow the transfer of assets, sort of as a proxy for innovation. Companies may not want to share their trade secrets, but their patents is a sign that they're innovating. Okay, let me turn very quickly to copyrights. I think we're a bit time limited. There are some libertarians who recently have called for the elimination or drastic cutting back of the copyright system. I don't think that's going to happen, but I think copyright protects not just writings, sound recordings, computer software, among other things, has long history. But some have argued that copyright terms have gotten too long, that copyrights are therefore are wasteful. But I would argue instead that copyright law has been able to accommodate itself to the new digital goods industry, has not created major problems for internet commerce. I think while there is some infringement, iTunes, Netflix, a variety of other sources in cyberspace allow purchasing of copyright materials for particular uses. And recently there's a book, and I won't say more about it, arguing that the copyright, great increase in the copyright term since 1790, have not really expanded the scope of copyright protection. They mostly reapplied the framers' approaches to calculating copyright term while adjusting for changes in average adult lifespans and spans and international norms, and that even if there's something to the argument there's too long copyright term, there is a serious issue about incentives on the margin to invest. There's a huge amount of maybe efficient, maybe not, piracy of copyrighted works, particularly in East Asia. So in short, I would argue that the patent and copyright systems are not perfect, but they should be viewed as copyright and patent systems should be viewed as protecting property. They're not quasi-property, not second-class property. They were fully understood as property by the framers using natural law reasoning, and they still, as recently as the mid-1990s, the administration, Democratic administration, understood copyright and patents as important forms of property. Before we start denigrating them and weakening them through lawsuits, through statutory changes and so on, one wants to be very careful, particularly given the, I think, pragmatic utilitarian arguments for strong rights in this area. Thank you.
Thanks very much, Mr. Abbott. Thank you for coming and joining us in our day of mourning in North Carolina. It's very kind of you to be with us and to grieve. There's much to say here, and Mr. Abbott has given you much to think about, a large portion of which I agree with, but I will strive to find some points of disagreement nevertheless. Thank you very much to Kathleen and to the Federalist Society for making this debate possible. I really appreciate your contributions to the intellectual life of the school. And in the spirit of that, the heading of the talk was Conservatives and IP, what does that even mean? And so for me, one of the exciting things about being involved in intellectual property is that from your political party affiliation, I can tell absolutely nothing about your views on intellectual property. And I view that as fabulous, right? So that this is actually an area where, if I know your views on abortion and perhaps gun control or your views on capital punishment, I can predict with some confidence a range of other views. I can tell almost nothing from those views in terms of your views on intellectual property. And this is actually great because it means that we can have creative thought, much of which I would have to say has been done by conservatives. And one thing which conservatives should be very proud of is the incredible range of intellectual opinions about intellectual property. There are people who take the positions that Mr. Abbott has nobly and notably defended. There are libertarians who view intellectual property as dangerous monopolies, largely granted by captured regulators and given out to favored companies, interrupting competition and the benign processes of the marketplace. And they'll quote Adam Smith. And actually John Locke, interestingly, who was against literary privileges on old books to that effect. There are economists like Richard Posner, law economists who argue that in general, while intellectual property may in fact be very positive, it is now far too long, far too strong, and far too vague, and who argue instead for what I'm going to call a minimalist approach. And the idea here is, which is we are certainly going to need intellectual property rights. The burden of proof should be on those who wish to extend a property right, to produce evidence that this is actually necessary, and to then go back after the property right has been extended or changed to see whether or not it actually produced the benefits which it was supposed to produce, and that the norm is competition. There are economists who have proposed, and this is not my position at all, that we should abolish intellectual property. So if you read Boldrin and Levine, they have a piece called Against Intellectual Monopoly, which argues that we can actually sort of do away with the whole thing. I think extremely unwise, particularly in the case of patents, like drug patents, where drug patents have their imperfections. They won't produce some social goods we need, but it seems to me that it's quite clear right now that drug patents are necessary in any kind of marketplace organized like the one we have. I could go on, but the point is what you see here is not a position in which I am conservative and therefore I think X and I am. Same is true of liberals. Justice Ginsburg has been a strong supporter of strong copyright on the Supreme Court. Justice Breyer, the other way around. When a very unwise and, in my view, constitutionally unsound decision allowed Congress to take stuff back out of the public debate and re-privatize it, one of the people who joined in the dissent was Justice Alito. The other person was Justice Breyer. One of these things is not like the other thing, right? This is, in other words, this is good news, right? This is intellectually open terrain in which we can and should think without the shackles of ideology limiting us. So that's the first point. On the natural rights point, I have to say I disagree. There was a notable absence, two noticeable absences in Mr. Abbott's talk. The first was Thomas Jefferson. The second was the Supreme Court. The Supreme Court does support property rights. The Supreme Court has been, I think, either unanimous or nearly unanimous in every decision it's ever talked about intellectual property rights in saying that the reason for the right was not the supposed natural right claim, but rather its utilitarian effects. Certainly in cases like Graham versus John Deere, where they're saying, look, so look at the clause, right? To promote the progress, Graham versus John Deere stresses that. Other cases have not, to be fair. This looks like a utilitarian grant for limited times, you know, sort of, you have a right to liberty for, I don't know, 10 years. You know, after that I'm going to take it away. You have a right to free speech. I'll give you 7, right? Now, we don't normally think of natural rights as having limited times added onto them. That seems a little weird, right? So this is a little problematic. Here's a quote which I think is nice. Monopolies, though in certain cases useful, ought to be granted with caution and guarded with strictness against abuse. The Constitution of the United States has limited them to 2 cases, the authors of books and of useful inventions, in both which they are considered as compensation for a benefit actually gained to the community as a purchase of the property which the owner might otherwise withhold from public use. There could be no just objection to a temporary monopoly in these cases, but it ought to be temporary because under that limitation, a sufficient recompense and encouragement may be given. The limitation is particularly proper in the case of inventions, because they grow so much out of preceding ones that there is less merit in the authors, and because for the same reason, the discovery might be expected in a short time for other hands. That's Madison, again, a different Madison perhaps. And I would say that the answer, the true position on natural rights lies between that quote and perhaps the ones that Mr. Abbott read. I would say that there was a recognition of that there would be no injustice in securing to an author and inventor a limited right in the occasion where that would benefit the public and where the thing was genuinely new. It wasn't like giving the king's toadies the rights to play monopoly over playing cards or sweet wines. It was actually, here, you're getting something, society. And that was both just and useful, right? So that's the way I do it. It wasn't that there was no justice argument. There was, and I think it would be idle to say that people never argued about the justice of IP rights. But they argued about them, and this is particularly true in the case of the Supreme Court, in terms of their effects. So how should we think about their effects? Well, here my muse would be Adam Smith, would be Thomas Jefferson, would be those who say effectively, the norm here is freedom, is competition, is openness. But we are open to you making the argument that an incentive is needed through a temporary and limited monopoly. And here's the key thing, temporary and limited monopoly, that the state should grant. And that we should grant that right for as short a time as is necessary to get the social good. We don't give you the right to the drug for 100 years or even 50 years, we give it for 20 years. That we should surround that right, as the patent system does, with requirements of disclosure and so forth, a very good thing. And that it's not just time that we should limit. We should also limit the reach of the right. Saying there might well be a right doesn't tell me how far the right extends. What is policed by the right? What behavior? In property law, perhaps this morning, you learned that this property isn't just sort of some whole thing which comes in a bundle. Property is a bundle of rights, and the question whether we give you one right out of the bundle or another right out of the bundle, these are separate decisions. This is, Jefferson says, we ought to look at what rights, what boundaries are worth the embarrassment to the public of creating such a right. So even if I give you some right, how far does that right? What behavior can you forbid? Can I stop you from decompiling my software? Certainly one of the natural rights Locke was concerned about, the state of nature. You may not decompile my software. I have mixed my sweat with those bytes. Or do you say, yes, you have a copyright over the software, but that's not going to allow you to stop someone else from figuring out how your software works in order to create an interoperable program which may replace you in the marketplace. Yay, competition. So what I've tried to give you is a sense of an open field in which, not decrying the arguments that Mr. Abbott produces, nevertheless there are strong counter strands, and that the utilitarian one has clearly been the one that has predominated in US jurisprudence. Of course, one can say that's wrong, and that's a perfectly legitimate and appropriate position. But I think that has been the position that has predominated in US jurisprudence. Not so much in Congress. Now, those of you who have studied the idea of collective action problems, and if you haven't, you should, know that we have problems with social policy under certain conditions. Those problems are when we have a concentrated repeat player with excellent information and a single interest that it wishes to pursue through the legislative or regulatory process, versus a disaggregated and not particularly well-informed group with high transaction costs, whose interests are, in total, much greater than the single player, but who face high collective action problems in getting together. Those of you who were traumatized by the Coase theorem may have a glimmering memory of how, if we assume that you can all get together frictionlessly, lots of problems go away, but of course, that is in fact a fantasy. Well, what does that describe? Well, I once explained particularly the copyright regulatory process to a political science scholar of collective action. He went, oh, it's the prettiest piece of collective action problems I've ever seen. In that we have repeat players with very stable views, generally the content industry. We have a large disaggregated public who's are not particularly well informed or well educated about the issues involved. And this makes it even better, many of the people at the table have not yet been invented. That is to say, the firms whose activities might be precluded by the rules that we're adopting don't exist yet because we're dealing with innovation. So Mr. Abbott offered you one baseline, which is we should be very careful before fiddling with the legal system. I agree. We have not been very careful in fiddling with the legal system. We have extended copyright rights dramatically over the last 100 years. As recently as the 70s, copyright lasted for 28 years with an optional extension for 28. 85% of works didn't extend, indicating that authors didn't want that right. 93% of books didn't extend. Kind of clear evidence for me that we don't need life plus 70. This is effectively us handing out a monopoly rent to a group of people, most of whom don't want or need it, causing as a result massively impaired access to our collective heritage for the benefit of a tiny group of insiders whose works are still under copyright and making money, which most of them aren't. the Gershwins, etc., and in the process denying us the public domain, massive social welfare cost, very little actual gain, and we would be far better off if we simply gave the people whose works are commercially viable the option to renew, let everything else fall into the public domain. This is exactly the kind of scholarship that the Cato Institute, Heritage Foundation has fought against, and I support them in those efforts and hope they will perhaps turn their eyes to copyright when they do. So I think this is a scheme where we haven't been cautious, we haven't been based on evidence, and I would offer the boring, this is the Boyle boring suggestion. The Boyle boring suggestions are as follows. That we should view the creation of legalized monopolies, which these are, in my view, they share, all property rights share monopolistic qualities. These share monopolies for a particular reason, namely the non-rival and non-excludable qualities of the goods they regulate. We should be very careful about extending them, as we have done with software patents, with business method patents, with extensions and broadenings of copyright. We should be really careful, here's another kind of caution, of the possible spillover effects. The white paper, the Clinton administration white paper, which Mr. Abbott quoted, proposed that, and only my IP students will believe that, and even this, maybe they won't believe it, that every intermediary on the internet in whose systems a copy, even if temporary, is created of a copyright work where there's no permission, that person is strictly liable. Think about this for a moment. So you send something you're not entitled to send to one of your classmates through the Duke servers, goes through then Time Warner Cable, and that person then posts it onto their website where Google spiders it. They're all liable. Somebody else then posts it to Facebook. Facebook's liable. Somebody makes a video of it, puts it on YouTube. YouTube's liable. Google copies the entire internet many, many times a day. According to this theory, which was the theory that the white paper of the Clinton administration, Democratic administration, put forward, they would be strictly liable. Every intermediary, every ISP, every search engine, every social media site, for any act of copyright infringement, even if they were not aware. You're going, yeah, but sorry, Professor, well, that can't be true because that would make Google illegal. Which people say this to me like, because gravity, you know, that would make Google illegal? Yes, that was the point. The internet, as you know it, would not exist had we followed those extremely unwise claims to apply, quote, existing law to this new technology. Claims which were made not only because of industries that promoted a particular worldview. This is not just a case of industry capture. That is not what I'm saying. This is a case of sincere belief. But the point was, extending that monopoly to this new technology would have denied us another technology, the internet. That seems like kind of a checkbox against that argument, right? Yeah, it seems like a good thing to me. Now eventually, and it was a really close run thing, we got exemptions and limitations, Section 512 of the DMCA, not required by the WIPO copyright treaties, something that was fought through in the United States process by a lot of people who were intellectual property minimalists and skeptics. And I think the internet's effect on speech and liberty, two things conservatives have traditionally cared about a lot, speaks for itself. I will finish up with just some comments on patents. I agree that some of the strongest cases for IP protection are in the case of patents. Basically, the strongest cases for IP is where you have enormously high upfront development costs. Cost of copying is low, where the process is extremely uncertain. So you need to incentivize someone to invest in an activity where most of their efforts are probably going to be failures. In that situation where you have no alternative mechanism, we could have other ways of funding drug development. We don't, largely. In all of those situations, the case is extremely high. But the thing about a patent over a single molecule drug is it's really clear. I know what it is, you know what it is, you're not going to infringe. Somewhere between 5,000 and 20,000 patents read on this thing, okay? And when I say somewhere between 5 and 20, no one knows, okay? Right? Not because they haven't looked, because the patents are vague. Many of the patents are bad, and I agree, you can't condemn a whole system just because a few patents are bad. He's absolutely right about that. But the point is, property rights work well under certain conditions. First of all, we know where they end. The picket fences around your house mark the edge of your property. Where are the picket fences of the mind? These are very hard. Where the properties do not involve strongly cumulative technologies that build and involve multiple forms of innovation. There we need to be really careful, because there, rather than having the tragedy of the commons, we might have the tragedy of the anti-commons, the tragedy of too many property rights, so that I'm terrified that I'm infringing your patents, so I get my own worthless patents and then threaten to sue you, and all of that works because it's mutual assured destruction until the patent troll comes in. There, I think we do need efforts to do it. And ironically, I think the people who will fight off patent reform are actually hurting the patent system, because I think people are making exactly the leap that he correctly condemns, condemning the system because of a number of bad patents. I think we do need patent reform, more reform, and I actually think post-grant review, it's not a panacea and there'll be abuses, but I think it's not a bad system. So that's my view, but the funny thing is there are people who are conservatives who agree with me, people who are liberals who agree with Mr. Abbott. For me, it is really exciting to be working on this area during a period of incredible ferment when there is evidence on both sides, thoughtful arguments on both sides. My own position, as I said, is very boring. Look at evidence, look before, look after, be humble about our ability to predict the need for intellectual property rights and rigorously scrutinize them once we've granted them. Thanks very much.
I agree with a lot of what Professor Boyle said. I think his remarks are very good, provocative. I do have a few things I'd like to say, however, in response. First of all, Jefferson, I do have about a page in my speech, which will be available from Kathleen Blanchard, pointing out, apart from the fact that Jefferson did not write the Federalist Papers, was involved in drafting the Constitution or the first Congress, some of his writings, you can find a lot in Jefferson. Good, bad, and ugly. And for instance, he wrote that at various points, arguably in an 1813 letter, that he doubted the idea of natural rights and real property. He sort of had, so I think he was something of a property skeptic. And at other times, he seems to say good things about property at other times. So you can find a lot in Jefferson, and it's tricky. And since he was not in a frame of the Constitution, let's keep that in mind. In addition, interestingly enough, when he was president, he signed laws expanding the copyright and patent laws, and said that, you know, an inventor ought to be allowed a right to the benefit of his invention for a certain time. Nobody wishes more than I do that ingenuity should achieve liberal encouragement. So anyway, I think Jefferson, difficult to say, it's a wash. I think the innovation in smartphones, tablets, it's true that there are thousands of patents, but interestingly enough, there are critics say too many patents, some bad patents, patent tickets. The area in which you've had the fastest innovation in consumer goods and the lowest in real terms diminution in prices in recent years has been precisely in those areas, such as smartphones, such as tablets, where you have huge numbers of patents. So I mean that, well, one of the reasons we need reform is because all these patents are gunking up the system and this litigation is harmful. It describes the very industries where innovation has been the fastest. So if there's harm, I don't think you can ascribe too much of it. Sure, there's some inefficiencies, but I think litigation sorts out a lot. Third, I think lots of economists would argue you should not describe patents as monopolies. In some cases, where there's only one cure for a disease and one molecule covered by one drug that's applicable to that disease, it may give you monopoly power. But you see in the 1995 antitrust guidelines, and what I think most antitrust economists would say, is the question is how many substitutes. Lots of patented goods, patented items have a few or dozens or hundreds or thousands of substitutes. In that case, the patent is a property right, doesn't convey monopoly. Just as property right to a particular apartment building doesn't make you a monopolist in the apartment market in Raleigh, let's say, to rent apartments. Also, I would argue that there has been expansion of copyright terms, I already talked about that, but as to public choice, there are also concentrated industries who are weakening, concentrated interests trying to weaken patents. I have seen, certainly in recent years, industries whose business model is to try and use patented technology, and if you can, don't pay much for licenses, or avoid paying licenses, or avoid looking to see if patents are covered. And by the way, those industries, some of them big manufacturing firms, whose I think Cisco, a number of other big firms, have joined together in lobbying to weaken the patent law. So yes, it is true that public choice talks about the concentrated interests of patent holders, but often some smaller patent holders, the small inventors, have argued, hey, we have less lobbying clout and we spend less money on lobbying than the big users of patents. So again, I think it presents a complex picture. But given the time constraints, again, I think Professor Boyle has written eloquently in this area, and I admire his work, and I think his comments were quite helpful, but we only have a few more minutes, so I'd like to sit down now and see if you have questions. Thanks.
Questions?
How do you actually evaluate whether a patent thicket is causing economic harm other than just, thinking about it?
That's a really good question. Mr. Abbott will have his own answer to it. First of all, you can't assume that because there's a theoretical thicket that there's actually a problem. Smartphones may be a current example of that. It's not clear how stable that equilibrium is. And part of that depends, I think, on what we do legally speaking. A classic example in this area is there's obviously a patent thicket in terms of genetic technologies, particularly in diagnostics. A lot of people, including myself, predicted that this would be devastating because, unlike copyright, patent law effectively contains no fair use, academic use, research exemption. There is an exemption, but it really doesn't apply. What happened, and our colleague Wes Cohen did research on this, is that he found that he surveyed academic scientists, and they said, oh, yeah, there are all these patents out here, and to do what I do, I'd have to clear hundreds of them, right? Classic thicket. But it's not impeding me. And he's like, great, why? And they're like, oh, because I ignore them. Now, that's, is that a stable equilibrium, right? It could be, because the firms might not want to go after academics, because what's happening in labs is hard to police, right? But then they said that about not having to get copyright clearances over course packs in universities. No one's ever going to go sue a copy shop or a professor or what have you, and that turned out not to be a stable equilibrium. And that may be a perfectly fine result, actually, in that case. But so I would say it is difficult. I think the key thing that you would focus on is the number of times when somebody has an innovation, seems clear they wants to do it, and they simply get bogged down in licensing, where the licensing demanded would be more than the gain. The classic example outlined by Rob Merges in a series of studies is the early aircraft industry, where basically the Wright brothers were fighting with competing patent holders, and eventually the government had to step in and sort of break the patents in order to get aviation going. So I think it is genuinely very, very difficult. My point is, if we hadn't started granting such vague and broad patents in the first place, the problem would be obviated.
Thanks. I think actually interesting, Adam Mossoff has written about this too. I think he might have a slightly different view on aviation, but he's written about the sewing machine patent wars, 19th century. But let me tell you how a lot of so-called thicket problems were avoided. For instance, in the 1990s, there were broad price cost licensing agreements among major semiconductor chip makers, Motorola, Nokia, Siemens, others, in which they agreed, they say, hey, we will license among ourselves, we will not challenge, we will agree not to challenge individual patents. It may be that some of those patents were not very good in the cross licenses, but this is a non-aggression pact. Indeed, you can have broad cross licenses, you can have patent pools. There are a variety of techniques to avoid the thicket problem and that have panned out. Then you might ask, well, why not just why do you need thickets? I mean, aren't these costly techniques? Well, the problem is as I suggested, the very effort of creating investing in a portfolio of patents. Some may be imperfect, but it requires a lot of work, and it is a signal to the markets for corporate control that you have a lot of innovative engineers and scientists, and you can't signal nearly as well with trade secrets and other technologies, which you can't or won't be willing to reveal because you're likely to lose them. So I think there are problems, but I think the marketplaces, there may be the occasional, the aircraft problem, but in general, the marketplaces handle them very well. And the idea that there are quote-unquote thickets may just, in fact, show something that's efficiency producing in a market for corporate control.
Jay?
I have a question about this theory of natural rights with IP and especially with copyright. And Professor Boyle suggested that we also need to look at the Supreme Court and Thomas Jefferson, and you look at other founders and a history. But I have a question about what you think about the fact that if you left your wallet on the table down there, probably no one in this room would take it. They would think that you have a natural right to that wallet, but I would guess almost every single person in this room has downloaded music and violated what you see as a natural right, but almost no one in this room probably has that same natural feeling towards that right, and at points has violated that natural right.
Well, again, that to me is a cultural issue. I mean, I think there are about a decade ago, many copyright holders were. I think the fact is that the fact that you find no problem in downloading someone is somehow not theft doesn't mean it isn't theft in some metaphysical term. It doesn't mean necessarily you want to prosecute it, by the way, but I mean it doesn't necessarily. We're not talking about sort of moral reprehensibility or non-reprehensibility of stuff, but I think there are lots of cultural norms. So I think you're implicitly saying, well, it's a cultural norm if people are doing a lot of this, that means that maybe it's different. Right, yeah, there are public good aspects of IP which don't exist with tangible properties, the whole discussion of rivalness, of non-rivalness of consumption, non-excludability. However, I think the problem is people, again, in doing a lot of free riding, are not bearing the cost, this may be, that it may be that some future improvements in software technology may come at a slower rate, that people are saying, look, we're getting some returns, but so much, there's so much free riding going on, hey, we're going to invest a little bit later. So again, it's the scene going back to Frederic Bastiat's The Seen and the Unseen. You see, say the benefits, what can be the hurt? Zero marginal cost or close to it of transmission, but there may be some longer term harms you're not perceiving.
And I would agree with that, by the way, at least the final comment. People often talk about there's no negative effects of things like illicit downloading. Well, here's one. So let's just, it happens to be illegal, at least in the United States. Beyond that, the fact that it exists leads there to be concentrated and very intensive efforts by the content companies to strengthen their rights in ways which may or may not manage to protect their content, but also may quite well seriously screw up the communications technology of the internet. So there are externalities to this activity beyond the moral claim that the artist might have on you, which is if you have a widespread activity like this and people say, oh, my revenue stream here is diminishing, the music business in general is making more money, but not the sale from recorded music because live performances have gone up. It will actually lead to, in my view, terrible attempts at regulation. And to finish with one final example of the irony of IP views, Bono, frontman from U2, not known for his conservative leanings, said, we should base our internet policy on China. They've found a way to regulate activity and we can copy them. No, actually no. I'm gonna say this is a case where the desire to regulate is, and all of us, well actually I don't download, I pay for my music, but all of those who download have a role in being responsible for that kind of reaction. Thank you very much for coming. Thanks to Mr. Abbott and thanks to Kathleen.